Okay, so good morning. Thank you for joining us on the fourth of our series of Brexit Brunch webinars, Contracts, Contract Disputes, Arbitration under Brexit, hosted by Lindsay Clegg and Jessica Brickley. Before I hand you over, if you've got any questions for any of the panellists, please use the Q&A function at the bottom of your screens. If you've got any technical issues throughout, please use the chat function and I can answer these. I'll hand you over to Lindsay Clegg. Thanks very much.
Thank you, Tom, and good morning, everyone. Welcome to our seminar today. My colleague Jessica Brickley is going to take you through commercial contracts in our new post-Brexit world, and then I'm going to look at the questions around enforceability of contracts and what you can do, and how the position has changed if, for instance, someone owes you money under a contract and doesn't pay, and how Brexit has impacted on that, where your counterparty is somewhere else in the somewhere in the European Union. So I will I'll pass on to Jessica. And she'll take you through the first part of our talk.
Great, thanks, Lindsay. So as Lindsay says, I'm Jessica Brickley. I'm a knowledge management lawyer in the commercial team here at Freeds. And today I want to talk about what's very much the key kind of commercial aspects of your contracts. So there'll of course be a collection of other sort of more technical points to consider, like things like definitions of territory, applicable law. And this session certainly isn't a substitute for having a lawyer actually look at your contracts, but it should give you a steer on how to think about key commercial aspects. So, as I'm sure we're all aware, Brexit has introduced a huge amount of uncertainty for businesses over the past few years. Brexit itself officially took place in early 2020, but the fact that it's taken time to negotiate a trade deal with the EU meant that there's been that uncertainty throughout 2020, and really there's still some there. However, the Trade and Cooperation Agreement that was entered into between the UK and the EU at the end of 2020 should remove some of that uncertainty and put businesses in a more informed position to be able to prepare their customer and supplier relationships and to mitigate the impact of the inevitable disruption. And the key difficulty, I think, facing businesses when contracting in the Brexit environment is in assessing the cost and effort involved in doing business and how to manage this in your contracts. Tom, can I have the next slide, please? Okay, now you can move on one more from that as well, actually. Thank you. So the first thing I want to look at is what are these uncertainties? What are the potential things that are disrupting our business environments? And of course, the UK-EU trade deal, as I mentioned, is one of the key things in this. Now, there are three main aspects to the trade deal. The first of those is what's the free trade aspect. And this is, I think, the bit that's had the biggest headlines. So there is this concept of zero tariffs for exports and imports between the UK and the EU. That was the headline. Actually, that's for UK originating products only. So there are actually a complex set of rules of origin that say what UK originating products are. We have what's called full bilateral accumulation. Now that's a jargon way of saying if you've got a UK originating product, but it's got some stuff in it that originated in the EU, that can still be considered a UK product. So all of this is a significant improvement from the WTO rules position that we would have had if there hadn't been a trade deal, and that will still apply for non-UK originating products. So for instance, under the WTO rules, exports of vehicles would have been subject to 10% tariffs. There were some tariffs around meat and dairy products that would be up as high as 40%. So it is a better position, but it's worth having in mind these rules of origin and you need to be careful that you're correctly declaring your products when you're exporting and importing. So, for example, just just to pick a product for white chocolate, if you want white chocolate to count as UK originating and to therefore not be subject to tariffs, the total weight of sugar that originates outside the UK or the EU must be no more than 40% of the weight of the product. So that's the kind of level of detail we're talking about in these rules, which is why they take up so much of the Trade and Cooperation Agreement. And the rule as being produced in the UK, even if, for example, all the actual components originate elsewhere. So for example, again, just to pick an example, if you dye yarn and weave it, that counts as a transformation, and so your end product is UK originating. But if you just dye yarn on its own, that's not enough to make it UK originating. So as I say, it's quite a complex set of rules, and it's worth kind of being really aware of what rules apply to your particular products. The other aspects of the free trade part of the trade deal.
Sorry, Jess, you're just cutting out briefly. I'm just going to stop. I'm just going to stop your video to improve the technical quality.
Okay, sure. Okay, are you okay for me to continue?
Yeah.
Okay, great. So there will be simplified customs procedures, but the border checks will still apply for all goods. So there will be an inevitable degree of disruption, additional paperwork, potential delay at the UK borders, which we've obviously already seen over the past couple of months, although to a degree it seems to be settling down. And then the last aspect of the free trade deal that I wanted to mention was this idea about technical barriers to trade being reduced. And this is about things like mutual recognition of regulatory compliance in various industries. So to give an example, in the manufacture of medicinal products, there are requirements to have good manufacturing practice inspections and certificates. And the trade deal allows for, say, a UK inspection of a UK facility to be enough for that product to be sold in the EU without having to have a separate EU inspection. And there's a whole collection of those technical barriers to trade provisions that intend to make trade easier. Can I have the next slide, Tom?
Lindsay, we just seem to have lost Jess there. Do you want to just pick up from your area until we can get back, Lindsay, get Jess back?
Yeah, that makes sense, Tom. Shall I move into do my half of the presentation, and then we'll pass back to Jess.
Yeah.
If you could move forward to my first slide, I'd be really grateful. I'll just turn my video back on. Sorry about that, everybody. I'm going to talk through jurisdiction, cross-border enforcement, and all the issues around whether your contract will be enforceable in the European Union post Brexit. Now, by and large, we don't like uncertainty. Disputes always create disruption for business, and they divert attention, time, and money away from what you really want to be doing, which is actually focusing on growing your business and your core business objectives. And my role as an advisor is to try and remove as much of that uncertainty as I can, and provide clarity and solutions to help people avoid the time and cost that's involved in managing a dispute. Brexit, unfortunately, hasn't helped those aims particularly, where we've got clients who are doing business with counterparties in EU member states. The Trade and Cooperation Agreement that was agreed on Christmas Eve made no long-term provision for jurisdiction. That's where a claim should be heard, or the enforcement of court judgment, so effectively how you get your money out of someone when you've won at court, between the UK and EU member states following the transition period on New Year's Eve. So I'm going to take you through how the landscape has changed in relation to contracts, their enforcement, and how disputes arising under them will be resolved in this new world. And everything I say here is where one party is based in, say, the United Kingdom. I really mean our jurisdiction, England and Wales, and another EU member state. What can be said, unfortunately, is that dispute resolution involving people based in the EU is going to become more complex, time-consuming and expensive. The procedures that are in place now aren't as streamlined or as modern as the ones we've unfortunately lost, and it's more likely that you will have to get local law advice from lawyers in the European Union jurisdictions where your counterparties are, because we're not benefiting from the one kind of composite rule book that we used to have across the EU member states. But what I'm going to do, I'm going to try and take you through the key changes so you're aware of them, some pitfalls to watch out for, and also some tips and tricks in practice that might help you mitigate the impact of those changes for you. Could I have the next slide, please, Tom? So governing law, effectively, this is which country's law will govern your contract. You should always include, when you're drafting a contract, a clause that says which law will govern it, particularly when you've got an overseas counterparty, because there's scope for all kinds of issues about whether your law, their law, or someone else's law should apply. Is English law still a good choice post-Brexit? Yes, it is. The reasons why people choose English governing law, and I get a lot of contracts come to me where neither party is English, but they choose English governing law as a neutral, fair, kind of next best solution. And the main reason why it's a great choice of law is that it respects the party's freedom of contract. So your contract will be interpreted to say what the written words actually mean. And that it might sound surprising, but in many overseas jurisdictions, particularly continental jurisdictions where they have a civil law form of law, actually the courts don't always interpret a contract to say what it means. There's this all kinds of notions like good faith and fairness which come in and which might invalidate a provision like a liquidated damages clause, that you think, well, you've got a clause that says if X happens, someone pays you Y. In England, they will pay you Y. If X happens, that's that. Whereas in places like France, if that's deemed to be unfair, it's kind of possible to get around those kind of provisions. None of these things are impacted. So certainty, respect for parties' freedom of contract, interpreting a contract to say what the written words say, are impacted by Brexit or the end of the transition period. The law that governs contracts made under English law is it doesn't change substantively as a result of Brexit. It primarily comes from our own common law rather than from legislation. And the courts across both the UK and the EU will continue to respect a party's express contractual choice of governing law, where they've got a term that sets that out in their contract. The rules that govern this, it's something called the Rome 1 regulation. They're not impacted by Brexit. They'll be continued to be applied as they were previously, both in the UK and across the EU. The picture does become more complicated if you don't expressly choose a governing law in your contract. This can be a real trap for the unwary, and you risk either foreign law applying, or even if it doesn't, a potential preliminary skirmish with your other party if one party wants to take action under the contract as to, well, which law actually governs it in the first place. And there can be real pitfalls there. So in a case that I've been dealing with recently, when you've got a distribution agreement under English law, if you terminate your distribution agreement in accordance with its terms, that's fine. Both parties walk away. Under a lot of foreign laws, some in the EU and some in the rest of the world, a distributor is entitled to compensation on termination, even where you've complied with an express clause in the contract that gives you a right to terminate, and sometimes even where the contract has just come to the end of it, it's expired, so the terms just come to an end. If you get local law, or if you don't have governing law, generally, if there's no express choice of law in a distribution agreement, it's governed by the law where the distributor is located, and so you can risk having to pay significant fees or significant compensation to the other side at the end of your agreement. Please always include a governing law contract clause in your contract. It's standard. You should include it even if it's a purely domestic contract. It should be objectionable to your other party, but it just removes any of the risk of these potential issues and risk of argument and side arguments with your counterparty. Could I have the next slide, please, Tom? So jurisdiction, where will any disputes under your contract be heard? Unfortunately, in relationships with someone in an EU member state, the end of the transition period has changed the rules applicable to contractual disputes and where they should be heard. The rules as to enforcement of court judgments have also changed. We've started to see some difficult questions on this and some real head scratching by clients. So jurisdiction, where a dispute will be heard. Is it going to be the national courts of your home country? So is it going to be in England, or is it going to be the national courts of where your counterparty is located? So potentially France, Spain, anywhere else. Most parties to a contract will set this out expressly within their contract, and I would strongly recommend that you always include a jurisdiction clause, even again when your contract is purely domestic, because it just removes scope for argument about this down the line. And in the absence of an express agreement within your contract, the rules that apply are quite complex, and they depend on the circumstance of the case and also the country where that particular question is asked. If you don't have an express choice in most circumstances, but it's not always the case, the position will be that you have to sue a defendant in its home country. So if you have no jurisdiction clause and you want to sue someone in Spain, you have to go to the Spanish courts and sue them there. The fundamental principles that make use of the English courts, and particularly our commercial court, a popular choice for resolving disputes, and particularly actually for overseas parties where they've got no links to the UK, they all remain. We've got a very high quality judiciary, particularly in the commercial court. They respect the party's freedom of choice, they respect the party's freedom of contract, they interpret contracts to mean what they say, and there's no suggestion of judicial interference, bias, home country favour, that kind of thing with our courts. Brexit won't change that, and it shouldn't actually cause any material issues in international contracts. It shouldn't change the position where you've got a contract with someone outside the EU. It's just the specific rules as between the UK and the EU that have changed. Before Brexit, we had a really good pan-European regulation called Brussels Recast that dealt with both jurisdiction agreements and also the enforcement of court judgments. Unfortunately, that doesn't apply to us when we're dealing with the EU, although it will still apply to disputes and debates across the between parties in two member state countries. So it doesn't disappear completely. It's just that we don't benefit from it in England and Wales. We were looking at joining or rejoining something in our own right called the Lugano Convention as a next best option. Unfortunately, that required the consent of the EU for us to rejoin as an individual party, and that's not been forthcoming, and it doesn't look particularly likely that that will happen. So what we're left with choice number 3, which is the 2005 Hague Convention. This is something that we were originally a party to as a member of the EU. So all the countries in the EU joined up as a bloc as of the 2015. We re-acceded, so we rejoined in our own right as of the 1st of January 2021. All the other EU member states are a party to this convention, so it covers disputes with anyone in the EU, and it also covers, bizarrely, disputes with anyone in Mexico, Montenegro and Singapore. And what it does, where you have got an express choice in your contract as to where which court will hear a case, the courts in those countries should still respect that. So it goes some way to plugging the gaps left by losing Brussels, but it's by no means as comprehensive. And there are real question marks about its application to 2 areas, and these areas are where you need to potentially just be a little bit concerned about. Firstly, the jurisdiction clause must be exclusive. If it's non-exclusive, so it gives, it says you should sue in England or Wales, but actually you can sue anywhere else as well. Hague won't apply, and it doesn't apply to non-contractual claims as well. So if you're suing someone for, say, tort, you're suing someone in negligence, it doesn't cover off those claims. You have to have a contract with an express contractual jurisdiction clause. There's some debate and doubt as to whether it applies to what's known as an asymmetric clause. Now, these are really common, particularly in banking and finance agreements. So your party with a stronger bargaining power, usually your lender, can sue the borrower anywhere it likes, but the borrower is forced to sue the lender in its home state. The view in England is that these are exclusive jurisdiction courts. The view in most of the clauses, the view in most of the EU is that probably they won't be. So there's a risk that if you've got an asymmetric clause and your counterparty tries to sue you somewhere in Europe, the court will say that Hague doesn't apply, and basically that they can sue you in their home courts. There's lots of commercial reasons why people use asymmetric clauses, and it may be that they outweigh the risk of Hague not applying, but it's something that you just need to be aware of. And if you're putting those kind of clauses into your agreement, just have a chat with the lawyer dealing with it and make sure that it will still be okay for your particular circumstance. Hague doesn't apply at all to any contract entered into before the 1st of October 2015, which is when the EU signed up to it. And there's a big debate about whether it applies to any contract that was entered into before we signed up in our own right on the 1st of January this year. The view of the English courts is that it does, so it covers anything from the 1st of October 2015. The view in the EU and the view of the person who actually drafted the Hague Convention is that no, it doesn't. It only applies from the 1st of January 2021. So there's been lots of debate, lots of academic legal debate about whether people should effectively re-execute their contracts entered into between those periods. In practice, I've not really seen this happening, but where it's a critical contract and it's worth a lot of money, you might want to think about doing that. Obviously, that requires your counterparty to agree, and you sign a short document effectively in re-executing the contract, which we can help you with. But it's just something to bear in mind, particularly when something is business critical. So what happens if the Hague Convention doesn't apply to your contract? So you've got a non-contractual claim, or you've got a contractual claim which doesn't tick the particular boxes. Well, if the English courts are looking at the question, then absent something unusual like a suggestion of fraud, they're still going to respect a choice of jurisdiction under the English common law. So they'll apply the rules that we currently apply to disputes with the rest of the world outside the EU. Then that's because they respect a party's freedom to choose where their dispute should be heard. If your case came before a court in a member state, European Union member state, then the position's a little bit more difficult because we lose the kind of the EU-wide rule book that used to be applied. I'd expect that most EU member states would respect an express choice of jurisdiction too, so they would respect the party's freedom to choose, but they'll apply their individual local national rules when considering whether they're going to do so or not. So there's scope for divergence across the EU, and you may need to speak to the local lawyers, and there's just that risk of uncertainty because we just don't know how a court in France, Spain, Italy will answer that question. If someone sued you there, we don't know whether that court would take jurisdiction of the case, irrespective of what was said in your contract. So can I have the next slide, please, Tom? You've sued someone, you've got a court judgment. Will you be able to enforce it? So will you be able to take it to France or Spain and get the money out of people, whether that is by attaching to money in bank accounts, by taking a charge over property, by sending the bailiffs around to seize assets? What we used to have was Brussels recast, which had a nice streamlined mutual procedure across the EU. That has fallen away unless you commenced your proceedings before the 1st of January 2021. So if you've got ongoing proceedings, those old rules will still apply. And similarly, we used to have something called the European Enforcement Order Mechanism that provided a streamlined enforcement mechanism where you've got judgment in default, so you'd effectively got an undefended debt claim. Again, we lose that for new claims going forward. So where are we now? We're back with Hague 2005 again. That provides some protection, but it's not as beneficial or comprehensive or modern as things used to be under Brussels. So Hague must apply. You must have an exclusive jurisdiction clause, and a judgment entered under an exclusive jurisdiction clause will be recognised and enforced across the EU as if it was a judgment of the country where you're going to enforce it. But you've got to tick those time boxes with when your contract was entered into, and there's the scope for uncertainty about the 2015 to 2021 period. And it also depends on the type of order you get. So if you get a money judgment, if you sued on a debt, that's absolutely fine. Your judgment says X will pay you £1 million. Where you might have a problem is things like interim protective measures, so something like a freezing order obtained on an interim basis, or something that stops someone disposing of an asset which fall outside the scope of Hague. So what happens if Hague doesn't apply? If someone sues you in the EU and brings their judgment here, we'd expect the English court, absent anything really weird like suggestions of fraud or someone didn't have a chance to appear in the original proceedings, the court should respect and enforce that judgment of a European state, so they'll be able to enforce it as if it was a judgment of our own High Court effectively. And similarly, most EU states will recognise and enforce foreign judgments, but they'll do them under their own individual local procedures. There'll be no pan-European regime if Hague doesn't apply. So there may be additional procedural hurdles. There's also that risk of uncertainty, and we're dealing with 27 different individual mechanisms for enforcement, so potentially you're going to have to get local lawyers involved in that jurisdiction when you go to enforce. So it should still be possible, it's just going to take longer, and it may well cost you a little bit more money to do that. So, I mean, the upshot is it should still be possible to sue a party across the EU where they don't have assets in the UK that you can enforce against, but it's going to be less attractive and it's going to be more expensive, and for lower value claims it might tip the commercial balance against actually taking any action. So when you are dealing with people in the EU, and when you're dealing with people anywhere overseas, to be honest, always look to the obvious mitigations. Avoid extending credit risk where you can do that commercially, and if you're talking about a lot of money, try and get things like guarantees, bank bonds, etc., based in the jurisdiction in England, from someone in England and Wales that you can sue against and enforce against here, to try and remove the risk of actually having to go out into the EU and get your money back. Could I have the next slide, please, Tom? So arbitration, and does this provide a solution to some of this risk and uncertainty? For anyone who's not familiar with arbitration, effectively, it is a contractual agreement between two parties to a contract to oust the jurisdiction of the court. So rather than any disputes being resolved by the courts, the parties use a set kind of agreed procedure. It's usually supervised and done under the rules of an arbitral institution, which provides a relatively kind of short rule book. It tends to be, you've got more control and flexibility over the procedure because it's consensual, it's a creature of contract. And the big advantage here, and one of the main advantages actually generally for arbitration, is on enforcement. So where you are taking an arbitral award, which is the equivalent of a court judgment, it can be enforced in the vast majority of trading nations, so everyone in the EU and pretty much everywhere else you would come across trading wise, so places like China and Brazil, where it's extremely difficult to enforce an English High Court judgment. You can enforce an arbitral award in the same way as if it was a judgment of the local court in that jurisdiction. So it's much easier to get paid with an arbitration award in the rest of the world than it would be with a court judgment. And arbitral awards and their enforcement under the New York Convention are completely unaffected by Brexit, because we and all of the people in the all of the other EU countries are parties to that in our own right, rather than parties as part of the European bloc. So potentially arbitration provides a safe harbour. It gets around all of these issues that arise as a result of Brexit, but it's not always appropriate for every contract. It tends to be a little bit more expensive to bring arbitration proceedings. You can't get summary judgment, so it is sometimes it's not that good for where you can have a lot of debt claims, and particularly smaller debt claims, and it can be more difficult where you are looking to do things like, rather than get a sum of money, enforce rights like use of confidential information, restrictive covenants, that kind of thing, where it may be actually more effective to be able to sue someone in their own local courts and get quick and effective relief there for those kind of disputes. So whether arbitration is appropriate or not all depends on the type of contract you've got, its value, the sort of relief you want under it, whether you are more likely to be the party suing, or whether actually you are more likely to be the party being sued and you're less concerned about how easy it is to enforce that contract. We've seen some movement towards arbitration, certainly in bigger, more high value contracts. But if you're thinking about it, if you've not used arbitration before, then I'm always happy to have a chat through the pros and cons and whether it might be appropriate, because it does depend on the circumstances of your business and your individual contract. Can I have the next slide, please, Tom? If you start proceedings against someone based in the EU, is it going to be difficult to serve them? Service out of the jurisdiction can be a real nightmare for clients. I've currently got a case running where we had to serve our counterparty, our defendant is based in Brazil. It took over 2 years to serve proceedings on Brazil, because you have to give notice to a defendant that proceedings have been commenced against them, and to be able to enforce any judgment when you win the case, you have to be able to prove that that notice was valid and that they had the opportunity to serve, and that's got to be valid under our laws and also their own local laws. So it can be a real issue in cross-border litigation. We used to have something called the EU Service Regulation. That was great. It wasn't as easy as serving someone in the UK, but it wasn't too difficult. It took a little bit longer. This applies if if basically documents have been sent to the European state before the 31st of December. last year, so it won't apply, unfortunately, going forward. So we turn to something called the Hague Service Convention. We're a party, all the EU member states are parties. That provides us a mechanism for service in Europe. It's not as modern or efficient as the service regulation, but it does provide something we can go to. But the other thing you need to be aware of with service outside of the jurisdiction now in the EU, which wasn't a problem previously, is in lots of circumstances, in not every circumstance, you need the permission of the English High Court to serve proceedings out of the jurisdiction on a defendant who's based overseas. We didn't used to need it because Brussels recast was an exception. So if you were serving under on an EU member state party, you just filled in a form and filed that with the court. And you don't need permission if you've got a Hague compliant contract. So that's one of the reasons why it's quite important to think about whether your contract does comply with Hague, and this is 2005 Hague that I discussed previously, because that removes that issue. So where you've got a non-Hague Convention contract, so your jurisdiction clause isn't exclusive, or Hague doesn't apply for one of the other reasons, or where you're suing someone for a claim that's not based in contract. So I've got some claims at the moment that are based in deceit and breach of statutory duty against people who manufactured vehicles overseas. They're non-contractual claims, so the Hague Service Convention doesn't apply, and you need to apply to the High Court for permission to serve out of the jurisdiction. And that isn't a tick box. You have to convince the court that it's the right place to hear the claim, the right country to hear the claim. You also have to convince the court that you've got a decent arguable case. So it's not a rubber stamping exercise. It's not a form. It's a proper application to court that will cost a few £1,000s, to be honest. So it's something you want to avoid if you can. There's talk that this is going to change. There's talk that for any contract that you've got an express choice of jurisdiction, you won't have to apply for permission to serve out, and they're going to change our civil procedure rules to do that, but they haven't done it at the moment. So as things stand, you're still potentially left with this quite expensive application to court before you even start proceedings. What there is, though, and my glimmer of light here is there is a way to get around that. It's something called an agent for service of process clause. Now, what you do in an agent for service of process clause is you contractually appoint someone as a postbox in England and Wales. So quite often it's an English lawyer, but it can be another company. And by sending proceedings in the post to that postbox, you have served them within the jurisdiction. You've served them in England and Wales. That's valid service, and you don't have to serve on them overseas. So that removes all of the potential problems of service out, and it also removes the problem of needing permission to serve out because you're not serving out. So it's something that I really, really strongly recommend anyone uses, whether their contract is with someone overseas in the EU or whether it's with someone overseas anywhere. And by overseas, I also mean places like the Channel Islands and the Isle of Man, which count as a foreign jurisdiction for the purposes of our courts, and it just circumvents, if the clause is written properly, it circumvents all of these potential issues and pitfalls and can save you a lot of time and money. Could I have my next slide, please, Tom? I'll move through this one very quickly because I'm conscious of time. But what happens if you've got a dispute resolution clause? Your contract says that disputes will be resolved in the courts of England, and your counterparty just ignores it. Our courts, if we've got a clause in a contract that says someone should be sued somewhere else, and someone starts proceedings in England, then absent something weird in the wider circumstances, then the English courts won't hear the case. They'll respect that party's freedom to choose, and they'll kind of require compliance with it. Courts in the EU should do the same thing, but they'll not be required to apply the same rule book, the Brussels recast regulation that they used to do, and those uniform rules. One thing that now happens, because those rules have fallen away, previously, if someone sued you in the wrong court in Europe, that court had the right to decide whether or not it heard the case, even if it was obviously the wrong court. So what people would used to do, it was called an Italian torpedo because the courts in Italy were notoriously slow. They would sue you in Italy because they knew they were going to get sued in England. They would get in first. The Italian courts would take several years to decide that they weren't the right place to hear the claim. And while that was happening, you couldn't take any action. and actually get on with the proceedings that you needed to take. The end of the Brussels recast as regards England and Wales has meant that we can you can now, if someone does that to you, apply to the English High Court for something called an Antisuit injunction, and that's an order of the court that prevents or restrains your counterparty from bringing or pursuing proceedings in the wrong place. They're not quick and easy things. Well, they're quick things to obtain, but you have to obtain them urgently. They're not cheap. They're quite a big application to the court, but in a big important matter, they're now available. Anyway, even if you're not looking at going for an injunction, if someone sues you in the wrong place, that's a breach of contract, and potentially you've got a damages claim against them for the losses they've caused, and that would principally be the cost of dealing with proceedings that are in the wrong place. So that's also an option. Can I have my next slide, Tom, please?
Yeah, Lindsay, we're on conclusion next, so I thought we'll go back to Jess and then finish with the conclusions for Q&As.
That makes perfect sense. Thank you.
Okay, thank you guys, and apologies for disappearing earlier. My technology let me down, but hopefully it will be fine now. I'm going to leave myself off video in case that was the problem. So I had mentioned we were on to the second limb of the UK-EU trade deal and this idea of wider economic, social and environmental cooperation. I mentioned the provisions around business travel and ensuring market access for service suppliers. One other aspect that I think will have an impact on commercial contracts is the rules around road transport, because hauliers that used to be able to just go into the EU and effectively do whatever they liked will now be restricted on being able to go to the EU, carry out 2 additional operations, which is going to drop-offs and pickups, that kind of thing, before they come back to the UK, but they won't be able to, say, take an empty truck to the EU, do some work in the EU, and then come back with an empty truck. So that potentially impacts on how you move your goods around. And they are also going to be subject to a set of standards on safety and working conditions like driver hours, much as they were pre-Brexit. One of the other aspects of this section of the deal that will impact on your contracts is data protection. However, I know this was covered by Luke Dixon in Tuesday's session this week, so hopefully you will already be up to speed on that. And then obviously there are a whole raft of other issues around energy, telecommunications, fisheries, a whole load of other things that are intended to deal with this wider economic, social and environmental cooperation. Can I have the next slide, Tom, please? Now, I think the issue with the trade deal, as I said at the beginning, it has removed some of the uncertainty as to how we do business. We know what tariffs we're subject to if we can work our way through the rules of origin. We know how things are going to be set up. But I think there are still uncertainties as to how this relationship is going to work. There are a number of things in the trade deals that require cooperation without there being detailed rules set out yet. There are a number of areas where there are going to be committees and working parties to be established. The Trade and Cooperation Agreement itself has a mechanism to be reviewed every 5 years. And so I think discussions around the UK-EU relationship are going to continue for many years to come. And that obviously leads into this ongoing uncertainty. Next slide, please, Tom. Then what other disruptors do we have to deal with? Well, I've just picked out 2 because I think these again kind of impact on what you're commercially doing in your contracts. One of these is changes in law. Now, as I think Lindsay will have mentioned probably while I was wrangling with my laptop, UK retained EU law effectively says EU law is, broadly speaking, incorporated into English law as it applied as at 31st of December. So there's very little immediate change to domestic law. There are some immediate changes where our law interfaces with the EU. So, for example, UK consumers will have their normal consumer rights against UK businesses, but not against where they're buying from businesses in the EU. And then longer term, it's inevitable that our laws are going to diverge from those of the EU. We're already seeing this in some areas, such as the withdrawal of the geo-blocking regulation. And I think there will be more and more situations where we can't assume that the way we do business in the UK is going to work for doing business with Europe. Now, there's also obviously going to be economic changes and that will impact on your contracts and the sort of uncertainty of the costs and risk of doing business. So performance of the pound, the impact on exchange rates, economic performance more generally, inflation, and the impact that that has on the costs of materials and other inputs. And of course, don't forget the other trade deals. We've obviously really focused on the UK-EU trade deal generally since the start of the year, but the UK has put in place a number of other trade deals with, for example, Japan, as well as a number of continuity deals that effectively preserve the status quo and let the UK trade on the same business that on the same basis that it currently does as part of the EU, or the same basis that it did as part of the EU. And there's a whole collection of other trade deals that are still under negotiation. So again, there are potential changes in the business environment coming down the line. So next slide, please, Tom. What does this mean for our contract? And as I said, I'm only really covering the kind of headline commercial points here. There are more technical aspects to deal with as well. But I think this comes down to two really key areas. One of those is the increased costs of doing business and who has responsibility for these. So this could be things like the cost of importing or exporting goods. So you might need to, if you're trying to move goods into France, for example, you might need to now pay for a customs agent to deal with all the border formalities. And that will add to your cost of doing business. You might also have goods spending longer in storage facilities because they're being held up at borders and they're having to sit somewhere while you wait to get them through a border control. Then there are obviously all the issues about moving staff around. So do you need to staff service provision from the UK, where you might have previously staffed it from another territory where it was cheaper to source people? Is it going to be more expensive or more difficult to get your staff across borders to provide services in other countries? So again, potentially more cost involved in providing the service. Then it's possible that obtaining the goods that you need in order to carry out your manufacturing or whatever it is that you do becoming more expensive and more difficult. And I think there's a really key point there, which is we think about the kind of implications of Brexit being about cross-border trade, but that's not just you selling your goods to someone in Europe. That's you potentially buying from a European supplier or even buying from another supplier in the UK who subsequently sources outside of the UK. You know, all of this will potentially impact on the costs of you doing business, even if you never speak to another person outside of the UK. And then, as I mentioned, changes in exchange rates. If you're doing business in euros, for example, obviously changes in exchange rates will affect your business, and changes in rates of inflation, again, could impact on cost of supply and all that kind of thing. Next slide, please, Tom. So with increased costs, if the contract is silent, it is pretty likely to be the supplier that's at risk. If you're the supplier, you're going to have been committed to providing the goods or the services to a timetable and for a price and to a specific place. And so the contractual mechanisms for allocating responsibility for increased costs is typically about the supplier, not always, but it's typically about the supplier wanting to push some of those costs onto the customer. So it might be express allocation of responsibility. It might be something in your contract that says the customer will be responsible for the costs of import and export border formalities. It might be that you have a price review provision which allows a supplier to take into account an increase in the cost of raw materials caused by inflation or unfavorable exchange rate fluctuations. So effectively giving the supplier a possibility of saying, look, it's cost me more money to produce this product now, so I'm going to need to put my prices up. And from the customer side, it might be benchmarking clauses that allow them to go out to the market and say, what is it that everyone else in the market is doing, either in terms of the type of product or the quality of products or the cost of products, and just to say, you know, supplier, are you doing what everybody else in the market is doing? Am I still getting a fair deal for this? So those are potential ways you can deal with the cost side. Next slide, please, Tom. The other aspect that I think is really key here is the problems with delays and difficulty in supply. And as I said, I think with increasing border formalities and changes in these systems as we go along, there are going to be these kind of issues. And again, it's a question of who has responsibility when those things happen. So if your goods are delivered late because there is a border delay and you can't get your goods to your European customer on the day that you said you would, or your goods or services actually can't be supplied at all because changes in law, say within Europe, mean that the standard that you have to meet in Europe is not the same as the standard you have to meet in the UK, and you suddenly have to rework all your products. or if your key staff can't be moved to the location where you're providing services because of all these issues around visas and not being able to spend long-term stays in the EU. Now, again, if the contract is silent on this stuff, it's probably the supplier that's at risk, because it's the supplier that said, I will provide you these things at this time in this place. Next slide, please, Tom. So the contractual mechanisms to deal with this are some of them around the same types of ideas. So express allocation of responsibility is, again, the obvious one. Something like the supplier will say, for example, delivery of the goods time is not of the essence. That's a bit of a legal phrase, and I'm not going to go into what it means, but it's effectively about how important it is that your deliveries are made on time. So you can deal with express allocation of responsibility, say time's not of the essence, time for delivery is an estimate only, those kind of things. You might also look at something like KPIs and service levels that give you the scope to have a percentage of what you're doing not be perfect effectively. So you're allowing for a percentage of failure. So for example, we could maybe guarantee as a supplier that 99% of our product will be delivered on time. That allows us a bit of wiggle room to say there will be the occasion where we get held up and where we can't do that. And those obviously then tie through to things like service credits and that kind of stuff. You might have some specific change of law provisions in the contract, which say if the law changes and it's harder for us or impossible for us to do what we're obliged to do under the contract, here's how we deal with it. You might use force majeure provisions, although I will say that very much depends on the wording of the clause. I think Ian and Nicola might have mentioned a bit about that yesterday, but that's force majeure clauses may help you if you're unable to do what you've said you can do under what you said you're going to do under the contract, but it's quite complicated. You really need to look carefully at how the clauses are worded. And then of course you might have termination provisions in your contract that say if the contract becomes impossible for you to perform, or if it becomes too difficult or too expensive, then you might have a termination provision that allows you to terminate. Again, very much depends on the wording. And of course, outside of the contract, those who attended yesterday's session on de-risking your supply chain will know there's a whole range of other strategies that you can use to mitigate risks outside of the contract, things like diversifying your supply chain. So next slide. I think that just as a general summary of all of this, what does this mean for contracts? The key takeaway, I think, is really thinking through what might actually happen. And for suppliers, is it potentially going to become more expensive or more difficult to move goods, difficulties in obtaining materials, the increasing costs of production. For customers, I think a key one that people quite often don't really think about is what happens if your own requirements change? What happens if you buy something now and you commit to, say a 3-year contract, and then the business environment changes and you don't actually have that requirement anymore? And I've just put a little note on there because there was a case very recently actually, and there's been a few cases over the last couple of years around situations where customers have entered into their typically leasing arrangements. So there's a couple of cases around aircraft leases. There's one about an oil rig lease, and they're all situations where customers have entered into a commitment. The most recent case on these, they'd entered into a 6-year lease of an aircraft. And they'd entered into that in 2017. And as you can imagine, March 2020 hit, and suddenly they didn't need this aircraft anymore because they were based in Oman, and the Omani aircraft authorities said no aircraft are going to fly in Oman because of COVID. And suddenly the customer had something that they had no need for anymore. And they had tried to, through the courts, and they used a mechanism called frustration, which was intended to say the purpose of the contract effectively has gone. We can't use this for what we wanted to use it for. And the court said, well, no, you can still pay for it and they can still provide it to you. So the core of the contract is still there. The previous cases that I mentioned, another aircraft one and an oil rig one, are similar sorts of cases with trying to use different contractual mechanisms. So one tries to use force majeure, another one tried to use what's called common mistake, and they tend to fail. All of these cases, that certainly the ones that I've looked at more recently, the courts are pretty prone to saying, well, you can still pay for it and they can still provide it to you. So just because you don't need it anymore, that doesn't change the fundamental character of the contract. So the upshot of all of that is you really need to think about this stuff up front. If what might happen in order to that changes your requirements, that means that you don't need this thing that you've bought anymore. And so I think it's a really key thing that I think is potentially not always really thought about. I think the next slide is the Q&A one, Tom. So I will hand back at this point to Lindsay to wrap up. And I think there's some Q&A that, Lindsay, it looked like, I think, are things that you will be able to answer.
Thanks, Jess. Sorry, that was a competition to see how quickly I could press my unmute and my start video button. So yeah, just running very quickly through my conclusion. Please always include and express a choice of a governing law in your contract. It's a fairly standard form. It should be uncontroversial, but it just removes that risk of issue and debate. And always as well have a clear jurisdiction provision. You need both of these. You either need an expression that the courts of X will determine disputes, or you need a reference to arbitration. You have either or of those, but you must have that in addition to a choice of a governing law. If you want to fall under Hague, make sure your jurisdiction provision is exclusive and avoid asymmetric clauses unless you are confident that the commercial benefits to you of those particular clauses and having that power or that entitlement to sue in other jurisdictions outweighs the potential disadvantages that might come with that. Always, please, when you're dealing with someone overseas, if you can, get an agent for service of process clause in your contract. If your counterparty has a lawyer in England and Wales, then they should be willing to act as an agent for service of process, but if they're not, then there are various companies based in London who will do that for them for a relatively small fee. Give some thought to whether arbitration might be appropriate depending on the terms of your contract, and say if you don't know anything about arbitration and you would like to know more about it, then I'm always happy to talk about that. And remember as well, with anything, don't give work you don't need to your disputes lawyers. Prevention is better than cure. So if you can avoid extending credit to anyone who's overseas, then try and do that. If you are extending huge amounts of credit, then try and get something like security or some kind of bond, some kind of guarantee based in this jurisdiction if you can, so you've got the peace of mind that you've got that there. And again, keep an eye on your relationships. If things start to go wrong, or you come across things and you think this might cause a problem in the future and you might need to change how that relationship works, then consider communication and dialogue. Is this someone that you actually need to maintain the relationship with? Are they business critical, whether in the short or the medium term? And if so, do you need to work with them and maybe discuss on a without prejudice basis and reserving all your rights, but work with them, have a chat with them to try and find a solution? And then if you find something that works, do you need to vary the terms of your contract? And if you need to do that, make sure you get something in writing that complies with all the terms in your contract. And it's not uncommon for a contract to say that any variations to it need to be in writing and signed by both parties. If you've got that, obviously you've got the documents to refer back to, and you've got no debate about what was agreed or whether anything was actually agreed in the first place. I can see that we've got a couple of questions come into the questions box, so I will just respond to them. Kate, you ask about contracts where you've got parties based in Scotland and Northern Ireland, and I'm assuming with your reference to employees there that these are employment contracts rather than kind of commercial contracts. If they are employment contracts, then under Rome 1, which applies to England and it applies to Scotland and Northern Ireland as well, you can expressly choose a governing law in those, and you can choose English governing law to apply to your employees who are based in those two countries. But what that won't do, and what you just need to be aware of, is that under the Rome 1 regulation, it won't get around any mandatory rules that apply in those countries. So if you've got someone based in Scotland and Scottish employment law grants them better rights than they get under your written employment contract, that in certain circumstances the employees could rely on those Scottish employment rights in addition to what's expressly in that contract. I mean, that would be the same if there were better employment rights in England and they were mandatory rights that you couldn't contract out of, but you just need to be aware of that. There's nothing per se to stop you having English governing law in those contracts, and simply if it's a commercial contract. And Albert has asked a question about whether post-Brexit we've got issues with the enforcement of injunctions. For anyone who doesn't know what an injunction is, it's basically an order of the court that either makes someone do something or stops them doing something. An order that stops people doing something is more common. So, for instance, an order that prevented a defendant disposing of an asset, or an order that prevented a defendant using confidential information in a certain way, or an order that a defendant has got a vehicle that belongs to you and they are required to deliver it up into your, so give it back to you in your possession. These are all injunctive relief. Hague applies for final injunctions. So if you go to the court and get an injunction at trial, so someone has got your vehicle, you're a finance company, they've taken it to Italy and they won't give it back, you can still enforce an order for delivery up of that vehicle in Italy. What you can't do, and where you need to be a little bit careful, is Hague doesn't apply to interim injunctions. So where you go to the court and say, this is really urgent, we need you to protect the position now before trial to stop someone destroying our asset or spending money that doesn't belong to them, and we need the court to hold the ring and protect the position until we get to full trial, which could be 12 months away. So Hague doesn't apply to interim protective measures. And so whether or not they are enforceable or not in European Union member states will depend on the local rules in that European Union state. So in some states they might be, in some states they might not be. And unfortunately, if you're in that situation with an interim injunction, you're going to have to speak, or get your lawyers to speak to someone in that local jurisdiction and get some advice about how the local courts would deal with that, I'm afraid.
Perfect. Thanks very much for that, Lindsay. I'm just conscious of time, so if we've not managed to get around to your questions, we'll follow up with those personally following the webinar. The slides and the recording will also be shared. And finally, just thanks again for Jessica and Lindsay's time. Thank you for attending, and hope to see you on the next one. Thanks very much.
Thank you, Tom.
Thank you.